In this video, I want to share with you a really unique resource that can help you in locating cases from the United States Court of Appeals for Veterans that you may be able to find a resource that would help in your claim in building your claim. So let's go right on into it. I'm looking very much forward to sharing this resource with you. I will be sharing the link down below in the description of this for this video. So here we are in the United States Court of Appeals for Veterans Claims, right? So you'll see here the United States Court of Appeals for Veteran Claims is a national court of record established under the Article 1 of the Constitution of the United States. So I wanted to share this with you because I think it'd be really unique resource to help you in building your claim. So let's have a look here. There are a number of different options. And here we're going to look for, there are active panel cases, there are class action, there are a number of different things, but I want to share with you specifically down here where it says search decisions. So it's right here in the middle, and click on search decisions. And you'll come to this website here, and you're going to type in a keyword, and that keyword most likely is going to be your condition or a condition that you want to find any court cases. So let's just put in, I think I put in like PTSD, I think at one time, so it remembered it. And when you click down on the down arrow button, you'll see all opinions decisions, single judge decisions, or panel opinions. So we'll go ahead and just select all, and then you could go ahead and then the next would be clicking the search button. It's going to come up with, it came up right here on the right hand side. There's over 7,952, and you'll notice here on the right hand side where it shares the date. All right. What I would encourage you to do to get some more recent, doesn't necessarily have to be recent, but I think it's great to see some cases that are recent. I would select the date, and you're going to notice that it went all the way back to 1990, and then click it again, and you're going to see now that these are the most recent on here. So you'll notice down here that there is a link to view it, have an outline, get some details, and find some similar cases. So you'll see where it kind of gives a brief description. It doesn't really go too much into it. So you're gonna, in order to look for something, one, you want to use a good keyword, right? Most likely the health condition that you're looking for court cases. And then if you want the most recent cases that have been decided, you want to come up here and hit date twice. So right here, it's saying filed September 11th, 2025, passive suicidal idolation. He has consistently denied plans or intent, quote, and that, quote, his depression and PTSD symptoms have not affected his ability to function independently, quote, at so forth and so on here. So let's look at, we can look at this one. There are others where it talks about his claims for effective dates earlier than November for post-traumatic stress disorder. A number of different things. So claim for service condition, PTSD, anxiety. So whichever one, looks like something you want to look into, you could go into view, and then you'll be taken to the claim. So here, you will see some things sometimes either typed in for some reason. I don't think it's necessarily to remove that information, but somehow it seems like it typed it twice or, covered. So what you'll see here is the appeals on April 16th, 2024. So this took a year. A Board of Veterans Appeals decision that denied a higher than 10% for a right ankle disability and a rating higher than 50% for specified depressive disorder. Record. So that's the case right here. It's basically a decision where it was denied a rating higher than 10% for a right ankle disability and a rating higher than 50% for a specified depressive disorder. And it'll go back into it. It gives this background. Maggie served on active duty. She in the United States Navy from 1990 to 1994. Let's see, in June 2020, he filed increased ratings claims for his service-connected right ankle and depressive disorders. In November 2019 and again in September 20, underwent VA medical examinations for his ankle disorder. The examiners both measured range of motion, but neither explained whether they used a goniometer to do it. On October 20, rating decisions, VA continued a 10% disability rating for the right ankle disorder and a 50% disability rating for severe disability, I believe is what that is, or severe depression disorder. Then appealed, challenging, among other things, the adequacy of 2019 VA ankle examination. And then it goes on to, it is the decision on appeal, the board evaluated 2019 VA ankle examination. And it says right here, the veteran representative argues that in November 2019, we could go on right here, right? So these are, just wanted you to see that there are some really interesting things that you could find in the event that you want to find some similar decisions that are similar to yours. And when you go into these different claims, you could find some very good information because, just to see, hey, what are some things that veterans have been denied? Which ones have they been increased for, so forth and so on. You'll see here that, so it's talking about an ankle disability and severe depression disorder. And it goes into what has been how it was explained, what's in the medical records, and then it goes into the appeal, where he argues that the board erred in relying on a November 2019 examination to deny a rating higher than 10% for his ankle disorder because it was not clear that the examiner used a goniometer as required under this rule right here, which is important, right? So he's saying that there's this flexion that wasn't measured during the examination that should have been measured. Now, he also argues that the board erred in denying a higher rating for 50% for severe depressive disorder because, among other things, it misapplied bankhead and silicone, right? So if this is something, perhaps you can look this up, the bankhead and skulkin 29 VA App 10, in analyzing his symptoms of suicidal ideation. The secretary disputes that the board erred by denying Mr. McGee a rating higher than 10% for his right ankle disorder, but concedes that the board erred in denying a rating higher for 50%. And then it goes on to more information, and it looks like, oh yeah, right here. There's 6 pages. And so you can look through these arguments and end up seeing where they, what rules they used, what regulations. Right here, it's talking about Rizzo and Shazinski, right? The presumptive of regularity is afforded to VA employees acting in their official capacity. This means that absent clear evidence to the contrary, this court will presume the VA examiner properly discharged his official duties. And, so there's a lot. There's Cohen and Brown. There's Frank Way and Wilkie. You may look through an example similar to your situation, and you may find some really unique things to look into. And these are some things that perhaps someone like myself would do for a client, but these are some things that you can do also for yourself to learn what are some things that went to the courts and how they can, what were the results? Why did they make those results? or why did they make those decisions, and so forth and so on. So you could see right here, the court sees no error in the board's factual findings to this end or in its reliance on the 2019-2020 exams. McGee does not suggest that the board overlooked or misconstrued any evidence that they could possibly constitute clear evidence sufficient to rebuke the presumption, nor does our review of the record reveal any sign of irregularity. The veteran is stating that this gonometer was not used because the examiner did not say that he used one, and that range of motion measures were taken during the exam dared to be rounded to the nearest 5 degrees. However, he has cited no authority for the presumption that the examiner must explain how the examiner arrived at range of motion estimates, including whether the examiner used a gonometer, and the court is unaware of such requirement. Indeed, examiners are not bound by any reason or basis requirement. And then it goes on to use another court case that stated that right here, Szczynski, and you can look further into what that case was all about. So then keep going, and then here's the conclusion. Based on the foregoing analysis, the parties' briefs, and a review of the record, that part of the board's decision denying a rating higher 50% for SDD is vacated, and the matter is remanded for re-adjudication consistent with the decision. The board's decision is otherwise affirmed. So they're going to be looking at that. So here's the thing that I want to share with you. Like you could be reading something like this for the very first time. All right. You could be reading something like this for the very first time. But if for some reason something just does not make absolute sense, for example, this conclusion, because you could be like, what does that mean? Does that mean that it's approved, or does that mean that he's going to get higher rated? So what can you do? Well, you could take this, right? You could take this and you could copy it. And what I would suggest is go to ChatGPT and ask to explain this. Now I'll give you two options. So let's take a look at those two options. Okay, I am using my veteran claims navigator that I created, and I went ahead and just put in, please explain the following decision from the Board of Veteran Appeals Court. And the part that I had copied, went ahead and pasted right here. I had to do some cleanup. So when you copy and paste it, just like I did previously, there's going to be some spacing that you're going to need to make when you just do that copy and paste. So here is what this means. So here it says that in part, the board's decision denying a rating higher than 50% for SSD is vacated and the matter is remanded for re-adjudication consistent with this decision. The board's decision is otherwise affirmed. So what does this mean? Vacated, legally termed, wiped out. The court found that the Board of Veteran Appeals made a legal or factual error in the part of its decision that denied a rating of higher than 50% for the service-connected depressive disorder, sometimes called major depressive disorder or unspecified depressive disorder. I was calling it severe depressive disorder. By vacating the court essentially erases that portion of the decision as if it never happened. Remanded means sent back for another look. The court sent the claim back to the board for re-adjudication, meaning the VBA must take another look and redecide the rating for SSD. On remanded, the board has to follow the court's instructions and correct whatever mistake was identified, such as failing to consider evidence misapplying the rating criteria in 38 CFR 4.130 or not explaining their reasoning properly. Affirmed means uphold the rest. And any other issues were appealed, were denied, and remained final. The court agreed with the VBA's decision on those matters. So in this case, this is only for the service-connected depression disorder, not for the ankle that we had or that was mentioned earlier in the same board court case. So here is what happens next. The board must redo its decision and on whether the veteran deserves more than 50%. Okay. Now, This is now where it's time to be working with somebody who knows what they're doing, which can submit additional evidence and argument while the case is on remand, right? So the board must apply the proper rating criteria for mental disorders under CFR 4.140, considering symptoms such as, and this is important, for those who this is really important right here, for occupational and social impairment, severity, frequency, duration of symptoms, right? And then if the board grants a higher rating, the effective date will usually be tied to when the increased severity was first factually accessible. Now, in a previous video, if you saw my video on intent to file, that's what this is talking about right here. And that's why it's so important to submit an intent to file, that because of this, it all goes back to effective date. And when you submit a file, or when you submit an intent to file, that date is very important. So when you submit an intent to file, you want to remember that date so that you put in your claim before that date. And you'll also remember that I mentioned that there are some claims, and you never know how long your claim is going to be or is going to take. It could take months, or it could take years for something like this, where this is what it's talking about. If the board grants a higher rating, the effective date will usually be tied to when the increased severity was first factually ascertainable, which means the intent to file date, the original date of the file. Now, here's the thing. If this veteran just submitted a claim without an intent to file date, and then the date that the veteran submitted the claim, that's the date. So from that date, if it takes 2 months, a year, 2 years, it's going to go to that date when the claim was submitted. Now, this is why it's so important to submit an intent to file, because you just never know how long your claim is going to take. And it just may go through something like this, where it's the Board of Veteran Appeals. Hopefully not. I am almost certain that this could have been a higher level review. It could have gone through that. I don't think so by what I read, but more than likely, it could have gone through a higher level review and letting the VA know where where there was the error, and then perhaps not have to wait a long time to go through the Board of Veteran Appeals, because that could take a long time. But it's also that they've got to go and take a look at that effective date. So basically, in short, the court threw out the part of the board's decision that denied a rating of 50% for depressive disorder, and it sent it back for another review, but left the rest of the board's ruling in place, which we know in this case was the ankle. This gives the veteran another chance to argue for a 70 or even 100% rating if the evidence, once again, as I have continued to emphasize in my videos, evidence. Evidence. Every claim that is approved is evidence-based. And right here, it's saying that it gives the veteran another chance to argue for a 70 or even 100% rating if the evidence supports it. If you watched my previous video about a veteran claim being denied, I mentioned in that video where when a decision has been made, whether it's 0%, 10%, 20%, whatever it might be, it will state why the decision was made for the percentage that was given and what would warrant the next level up. And in the video case, it was the 10% level higher. So in this veteran's case right here, the veteran reading that decision letter would have seen what would warrant a higher percentage, and perhaps he felt, or this veteran felt, that he should have received that higher level, which then it begins the process of either going higher level review or a supplemental claim, or a board of appeals. So I don't see anything of it being going through a higher level review that I'm recognizing off the bat, but it and so it may be, and I don't think it's because this board of appeals could take a while, and in fact, for this one, it took a year. If you remember, it said something about um, said something about 2024 right here. Counsel appears on April 16th, 2024, and the decision, or at least it being filed, was a year later. So let's see if there is a date right here, dated. So this took a year. This took a year. So once again, going back to the going back to the intent to file, you just don't know how long it's going to take for your claim specifically. It may be approved. It could be denied, where then you submit for a higher level review. You're not submitting any new evidence. It could be a supplemental claim where you're submitting new and relevant information, where, the time to where you submit a claim and the time where you go through all the exam and you finally get a decision, that could be 3 or 4 months. Well, during that time, you could have maybe perhaps gotten an MRI or gotten a CAT scan, or some sort of other information that would have been helpful had you had that information before you submitting a claim. So that would warrant a supplemental claim, even if it was approved. And this is a good point here. Even if the claim was approved, um, even though a claim was approved, you could, and if you have new and relevant information, so let's say, for example, you get approved for lower back at 10%, and you see that the decision, that it also includes why you didn't receive 20%. And let's just say that during the time period where you were waiting for the decision, you just happen to get an MRI. This is just an example. Even though you got approved at 10%, that's great. But then you submit a supplemental claim adding that MRI, because at 20%, it states there's got to be some nerve damage or some touching of the nerve or something for 20% for lower back. You can then submit a supplemental claim and say, and state that as a result of these MRIs that I have, I should be at the 20% level. That claim should go right through, and the veteran should be right at 20%. So really important information that you can. Let's go back. So this is one example. Let's go back. So let's go back one more, just as another example here. Once again, let's say, let's. I usually tend to go to PTSD, TMJ. What are some, um, uh, thinking of some recent claims? Yeah, we could do sleep apnea. I know that's been a huge one, but I've been using these. Once again, it doesn't really matter. You'll see, look at this, 2019, right? So let's look at some, and there's no descriptions, which is interesting. Excuse me. So let's go and click date twice, because this is going to go back to 1998. Click it again. And now we're back to September 2025. So right here, it's saying something about award of service connection for obstructive sleep apnea and effective dates for service connection for sleep apnea. Conditions including PTSD and anxiety and sleep disturbances, including sleep apnea. So let's take a look at this one. This is a recent one. So here, once again, filed 2025. We're looking at the appellant, and here we go. So this person served from 1997 to 2003. He appeals a board decision that denied his claim for service connection for painful joints, a mental health condition including PTSD, anxiety, and something disturbances including sleep. Um, there is 2025 the court order. Okay, so on further consideration, the court since ordered the case to be returned for a single judge disposition. Because of this, the appellant's motion for clarification of issues for oral argument filed on August 13th, 2025 is moot and the court denies it. So it looks like, so as the merit argues that the board erred in not ordering a medical exam for the painful joints and mental health claims and relied on an inadequate exam and denying the, looks like, sleep disturbance claim, the court finds clear error in the board's decision regarding Mr. Ruiz Sanchez's painful joints and remands that claim. But the court affirms the board's decision to deny the veteran's mental health claim and dismisses his argument pertaining to his, I believe, sleep disturbances claim. So you can go through this, and once again, if there's anything that you don't understand, copy it and paste it and put it into Chat GPT. I believe. Let me, if you want access to my GPT, comment down below GPT and I will get that to you. Also, if you don't want it, this is something else you can do. So if you go over to, so let me first go down, and I want to, so once again, be mindful of other court cases and what it states. So let's go down to the conclusion right here. For the reasons explained above, the appellant's August 13, 2025 motion is denied as moot. Further, the portion of the board's March 27, 2024, looks like it's been at least a year, decision denying a claim for service connection for painful joints is vacated, and that matter is remanded for readjudication consistent with this opinion. The portion of the board's decision denying the veteran's mental health condition claim is affirmed. The remainder of the appeal, including the veteran's arguments related to his, I'm going to say, sleep disturbances. So we could go, wait, did that just highlight? So it revealed sleep apnea is dismissed. All right, so let's copy this. Let's go to Chat GPT. I'm going to start a new chat. So this is a new chat, and it's not part of my veteran claims navigator. So if you're going to use something other than mine, here's what you want to type in. So I'm going to go and paste this. And I think I mentioned to you when I did, I had to do some cleanup. So I'm going to pause it. I'm going to clean it up, and I'll be back. All right. So we're back. Now, if you're going to you're just going to copy something and paste it right into Chat GPT, use this command right here. Act like a professional lawyer with 30 years of experience representing veterans who have filed a claim under the Board of Veteran Appeals. I want to know what the following means. You could say in layman's terms. So what you want, veterans appeals, right? So act like a professional lawyer with 30 years of experience representing veterans who have filed a claim under the Board of Veteran Appeals. I want to know the following, what the following means in layman's terms, right? Just something like that. And I'll go ahead. So you saw previously what my GPT produces. Let's see what this one produces here. I don't think I mentioned layman's terms in my GPT, but that's okay. So you'll see the difference between the two. So the appellant August 13, 25 motion is denied as moot. The veteran filed some type of motion or request on August 13th. The court says it's moot, meaning that it doesn't matter anymore because the issue has already been resolved or is no longer relevant. So they didn't decide on it, just dismissed it unnecessary. The portion of the board's March 27, 24 decision denying a claim for service connection for painful joints is vacated, and that matter is remanded for re-adjudication, consistent with the opinion. Now, it's not saying what vacated means or remanded means, but here it goes. Or actually, it does erased or overturned, just in a different way. It doesn't highlight it. Well, it highlights that, but it doesn't. But no, it's still great. It's still good. It was painful joints. The higher court has now vacated, meaning overturned that denial. It was sent back, and then now this means that the veteran's painful joints claim gets a fresh review. All right. So then you'll see where so anything that you want when you're going through these court cases, simply come over here. If you have my GPT, utilize that. If not, type in something like act like a professional lawyer with 30 years of experience representing veterans who have filed a claim under the Board of Veteran Appeals. I want to know what the following means in layman's terms. And you could also do for any court cases. You'll often see, let me go ahead real quick back to it. You'll often see something like right here, Messi and Shinshik, right? You could put that and say, what does that mean? You could come up here and type, copy this whole paragraph. It's something that doesn't make any sense. Go to copy and then go back and type this in, paste it here, bottom, and then put this before, and then paste what you copied from the Board of Appeals, and learn some stuff that may be very beneficial for you in your claim. So as you have seen, the all this is based off of evidence. So every claim that is approved is based off of evidence-based claims. I have a video about evidence-based claims. Check that out, and other videos that I know will help you in preparing or having a powerful claim that will help you in this journey of submitting, excuse me, or having solid claims that are backed by evidence. All right, go check out that video now. Thank you for watching, and I'll see you in the next video.